You're listening to Get Hired Up, the podcast for next-level executives and board nominees, the fun and informative podcast with host Maureen Farmer, CEO and founder of Westgate Executive Branding and Career Consulting. Westgate is a 100% independent premier executive branding and career services firm for high-profile leaders who are serious about navigating the hidden job market to get hired up. And we especially love helping successful executives make exciting career moves that let them be leading heroes at home, not just at the office. So if any of these challenges are ahead for you, visit us at westgatecareercoaching.com.
Hello, this is Maureen Farmer, and I am CEO of Westgate Executive Branding and Career Consulting. Our firm has served clients around the world since 2011. And our website is westgatecareercoaching.com. And today I have the pleasure of speaking with Amy Bradbury, employment lawyer and partner with Wickwire Home. Amy has expertise in a number of areas, including workers' compensation, labor relations, pension and benefits, judicial review, and of course, employment and labor law. So today we're going to discuss current trends in employment law and more specifically in the area of employment due diligence process from both the candidate's perspective and the employer's perspective. So, Amy, it's such a pleasure to have you here. And I'd love for you to talk a little bit about your background and who your firm serves.
Sure. So I'm a labor and employment lawyer, and I've been doing this type of work for a little over 20 years. And I am working at Wickwire Home. I'm a partner there, and I've been there a little less than 2 years. Wickwire Home's a full-service law firm. We have about 20 lawyers, and we have a very busy labor and employment practice. In my practice, I represent both unionized and non-unionized employers, and I do some work with unions periodically. And I represent employees as well, and usually employees who are at the executive level. My clients come from a large variety of sectors. I work with clients in private industry, and also with clients in the nonprofit sector. I really enjoy being a labor and employment lawyer. The work is interesting. It's an area of law that changes all the time, and
I was just going to say.
What? Pardon me?
Oh, I said. There's no doubt that it's changing all the time.
No, exactly. Yeah. But that's because workplaces are always changing and evolving. I do see recurring themes in my work, but I always see situations that I've never dealt with before, and that's part of what makes the work interesting, and that allows me to be innovative in the solutions I create for my clients. And I also enjoy helping employers with the decisions they're making and help them to operate within the boundaries of the law. I work with clients to improve their workplace culture, and it's really rewarding to see employers make changes and the positive things that result from that.
Oh, yeah, fantastic. Excuse me, employment law is critical work. There's no question. And I remember when I met you initially, Amy, when you were at your last firm, I was doing some work for a couple of your firm's clients in the area of career transition. And over that time, because I worked with these customers or these clients actually for a number of years, I learned, really the importance of legal counsel for two things: to protect the interests of the business while ensuring employees are fairly treated. Because obviously how employees are treated impacts the business's reputation and their brand, if you will. And also, employers want to support their employees who may be exiting the business. And I know this sounds obvious, but excuse me, in my own work as a career and HR consultant, I've witnessed CEOs and their teams treading into some tricky areas. So with that sort of lead in, what employment trends are you currently seeing from your clients, and what's impacting their business?
I think leaving aside, the most recent challenges that we've had with the COVID-19 pandemic, and a lot of employers have been struggling with that. One of the largest issues my clients face is attracting and retaining good employees, particularly employees at the executive level. They struggle to find employees with the right skill set and who will fit well within their business. A lot of my clients invest a lot of money in recruiting, again, especially at the executive level. And it's disappointing for them when the hiring doesn't work out, and then they're left having to spend that money again. So I think it's really important for employers and employees to start the employment relationship off on the right foot and make sure that both parties understand the nature of the employment and what the employer is looking for, and that the employment will be a right fit for both parties.
Absolutely. I mean, we want it to be a win-win outcome for both the employer and the employee, and there is a significant investment that organizations make while recruiting, selecting, onboarding, and training. And some estimates, according to the Society of Human Resources Management, is anywhere between 90 and 200% of the person's annual salary. So that's a huge investment that organizations are making, to bring on the right type of talent. And I myself have worked in large corporations where we had undergone a national search, for example, and brought in an executive from another part of the country, and on 2 occasions, in fact. And within 2 years, we lost both of those individuals. So it has a huge impact, not only on the employer, but also on the employee as well, because both of these executives uprooted their families to move, like, literally from the West Coast to the East Coast. And, it's just a huge loss for everybody overall, because, at the end of 2 years, there's very little to account for, especially at the executive level. So given that, in your experience, Amy, what do you think that both organizations can do and candidates can do to ensure that there's the right fit?
Well, I think that both the employer and the candidate should spend a fair bit of time getting to know the other side and making sure that it is going to be a good fit. And so, that includes things from an employer's perspective, like having more than one interview with a candidate, having the candidate interviewed by different members of the management team and getting the feedback from those different interviews. Everybody has a different perspective, and I think the more people who meet with the candidate and can get an assessment of what they think, it's a good thing. And then if everything is going well, bring the candidate into the workplace and have them sort of see the operation, what goes on, during the course of a day, and see how that interaction goes. But also, I think candidates often focus on salary or benefits, but I think they should be looking for information about the workplace itself and how the employer approaches work, what their culture is, how the employees interact and work together, and what the employer does to help an employee grow in their career and in their professional development. And I think the more the candidate knows about the workplace culture, the better they'll be able to assess whether it is a place where they can be long-term, and it can help the employer get a better idea about the fit as well.
So that's a really interesting advice, because one of the individuals I was working with, it was a senior level employee. What he did, he was invited to a team dinner with the then CEO of the company. It was a large company, and they were recruiting this individual. And during dinner, the CEO kept looking down at his iPhone and answering or sending text throughout the entire dinner. And so my client took note of that, and it wasn't the exclusive reason or the only reason he turned down the job offer, but it was part of it, because he felt that if the CEO was going to be on his phone during the dinner, what would it be like, trying to get access to this person on a daily basis. So there's these little things that both employers and employees can do to sort of test the culture. Would you agree?
Yeah. And as I say, those things are little red flags, right? That should give the employee pause and make them think about, is this somewhere where I really want to be, and does it work with my life and what I'm looking for? And as you say, one of those things by itself probably isn't going to cause an employee to turn down a job offer, but if they start to see more of them, and there are several things, then all of those things can come together and keep the employee from taking a job offer. And I think that's quite appropriate. I think, as I say, people are looking for a long-term relationship on both sides.
Absolutely.
Most people are looking for that place where they will spend a fair number of years working and growing and developing. And so it's important to take that time and make sure that it is the right environment and the right fit for you.
No matter how attractive it looks.
Exactly.
Yeah. So, Amy, what's in terms of the due diligence process, what would you say is the single biggest mistake that employers make when they're completing their due diligence for hiring a new employee? So, does the due diligence process work differently for more senior level employees, say at the executive or board level?
I think that there are some differences at the executive level, but there are a couple of mistakes I see employers make all the time, and it's true for almost every employee they hire. The first is not providing for a probationary period for the employee that they're bringing on. And this, I think, a lot of times people are focused on, again, the terms and conditions of the employment, the salary, the vacation, the bonuses, rather than focusing on what happens if this doesn't work out.
Right.
And so it's surprising to me how many times I see that an employer has not provided for any probationary period at all, or they provide for a probationary period that's just inadequate. A lot of employment contracts I see have a probationary period of 3 months, and that might be sufficient for a frontline type of employment. But when you're getting into executive and board level positions, you need a lot more time to assess whether that senior level employee is doing a good job. The tasks that they do often. It takes several months to even see them perform them all to make sure that they are doing a good job on all of them. And it can take several months to determine whether they are respected by the people who work with them or whether they're a good fit.
Right.
Now, of course, I do see as well, though, and this goes back to the difficulty with recruiting, that some employees are not prepared to sign a contract that's got a probationary period in it. They're leaving. They may be leaving another job in which they have fairly secure employment, and they don't want to risk being terminated during a probationary employee with little or no compensation for that termination when they have other employment already. And so sometimes employers will make that decision to waive the probationary period to secure a really good candidate. But that's risky, but I do see it happen. And then apart from the probationary period, it's really amazing to me how many employees get hired without any comment in the employment contract or letter of offer about what happens if the employee has to be terminated. And quite often the contract doesn't contemplate that at all. And so you are left then with common law reasonable notice, which can be very expensive, particularly, again, when dealing with a higher-level executive employee. And there's a third area that I think comes up particularly with executive-level employees, and that relates to restrictive covenants and whether the employee is coming to them with some restrictions on the work they might be able to do. And so restrictive covenants are things like non-solicit and non-compete agreements. And so a non-solicit, of course, it can prevent the employee from working with former clients, with their old employer, or recruiting former clients, or recruiting former employees. They may have a coworker who they work very well with, and a non-solicit may prevent them from soliciting that employee to join them as well. Whereas a non-compete is even more restrictive. It can prevent an employee from working at all in a particular area or a particular business, and that's usually for a set period of time. Both those types of provisions usually have a time limit on them. And so, an employer may find a very attractive candidate and then find out that they are bound by these restrictive covenants that would prevent them from working in the area, or might prevent them from trying to bring clients in if they were clients at their old employer. Now, these types of provisions, courts don't like to enforce them. They're seen as a restraint of trade, particularly the non-competition provision, because it keeps an employee from working in the area where they have expertise and prevents them from earning a living. But the courts do look at whether those types of provisions are needed to protect legitimate business interests. And so that depends on the type of work that the employee was doing and the type of information they had access to. So they can be upheld in certain situations, and particularly if the old employer needs that kind of protection. They are more enforceable generally against those higher-level executives because they have more knowledge of the plans of the business of their former employer. They have inside information about pricing or business plans, which can make those clauses necessary to protect those legitimate business interests. And so employers, or the new employer that's looking to hire, quite often doesn't ask questions about those types of restrictions or commitments that might exist. That doesn't necessarily prevent the employer from hiring that employee, but I think that the employer needs to have a look at the language and assess its enforceability and make a decision about whether they want to hire the employee and risk having litigation started over those provisions or be involved in that type of litigation.
These things tend to come up later on, in the process. So basically, is it up to the employee or the candidate, rather, to disclose these covenants to the new prospective employer? I'm currently working with an individual who has a non-compete. However, he was recruited by that organization where he signed the non-compete and was only employed there for 90 days, and then he and his entire team was terminated without cause. So within a 90-day tenure and a non-compete clause, he's concerned that the new employer, he's being interviewed by this new organization, may not consider his candidacy. So now he's in that situation where, he has to disclose the fact that he has the non-compete, but after, 90 days, he's had it reviewed by a lawyer and so forth. But it's just that difficult, delicate Texas two-step that employers and candidates need to think about and do their due diligence, in that moment.
I'm seeing more and more that is part of the employment contract, that employers are asking and are requiring employees to disclose that. But if the employer doesn't do that, I think that employees risk really starting the relationship off on the wrong foot if they don't disclose it. And they can, the employee can explain the situation. They can provide the language to the employer. And the employer can then, as we said before, make a decision about whether they want to take that risk. And I'm often contacted by employers when they're in the final stages of hiring and asking me to look at a non-solicit or a non-compete and comment on what I think about its enforceability. And in the case of the client you're working with, to have such short tenure of employment and then expect that the employee can't work for a competitor, for probably a longer period of time than they were actually employed would really affect the enforceability of that provision. But I think, advising employers of that situation ahead of the hiring is really the way to go. And, I see situations where an employer receives a cease and desist letter from the counsel for the employee's old employer. And that really doesn't set a very good tone for this new employment relationship. Quite often the employer is more than willing to defend against that and to support the employee in that, but it really does affect the employment relationship starting out.
Oh, I agree 100%. So that's on the employer side. What would you recommend to an executive job candidate? What is the biggest oversight that you see these individuals make when considering a job offer or negotiating that contract?
I think a lot of times the candidate is really anxious about getting the job and starting that new chapter of their life. And so they don't take the time to really look at the offer that's being made and reviewing all of its terms. Employees are often focused on things like benefits and salary, and they don't think about looking at those termination provisions we talked about earlier, or looking at whether there could be restrictive covenants that could affect their ability to find other employment if they move on. But apart from those sort of contractual things, and again, I think this goes back to what we were talking about earlier, I don't think candidates ask enough questions about professional development and corporate culture, how the employer handles issues and concerns that might come up in a workplace, how they handle conflict. And so employees often accept a job offer and then find themselves working in an environment that's really unpleasant or doesn't allow them to develop their career the way they thought. And again, I think employees or candidates, when they're trying to be agreeable with this new employer, they're trying to show the employer that they're easy to work with and there's not going to be any pushback on things. But ultimately, they may be doing themselves a real disservice and not pushing on those issues, again, where they see those red flags.
Right.
And this, I think there is room for employees to do that. I think particularly at the executive level, employers have put a lot of time and effort into the recruiting. There is room for those employees to discuss those issues and to negotiate terms that work better for them. And I think ultimately it will be a better relationship and both sides will be a lot happier.
Absolutely, and I think that it is expected at that level that candidates will negotiate, although depending on what situation the employee is in. And here's an example, a really interesting example. I once worked with an individual who had accepted a senior level role in Toronto, and he's originally from Europe. And because of where he was from, he was not a Canadian citizen. He was sponsored by the company. Anyway, he was thrilled to come to Canada. He settled in with his wife and 3 children, found a great job. And his wife found a great job. He already had the job. And soon after he started, during the onboarding, he discovered that he would be responsible for 30% of his job would be business development, and he was hired to do IT operations. And so given that he had no business development experience or training and had no network in Toronto, it put him in a pretty tight bind. And he was quite upset about the discovery. He had already signed the contract, and, he was really, again, stuck in a hard spot. And, of course, we all learn from our own clients. We learn from our own experiences. And, based on his experience, I'm always leery of when the candidate doesn't ask any of those questions. And I always recommend that the candidate ask questions such as, and you have to find your own way of saying this, of course, but is there anything required in the role that's not included in the job description or the employment contract? And I think that's a pretty fair question. I think a lot of, like as you just said, many people don't think to ask these types of questions because they're eager to start the job and get caught up in the excitement of it and want to start off on the right foot. So I always recommend that the candidates ask a series of questions, almost as though to test the culture as you're moving along in the process. So, for example, if you are concerned that you may not get access to your CEO or whoever the decision maker is, you can always test that by asking for another meeting before you sign the contract. There's all kinds of things you can do, as you mentioned before, on the employer side, where we bring the candidate in to be interviewed by sales, by finance, by legal, by all the different areas, functional areas of the organization. The candidate can actually do the very same thing as well.
Yeah, no, and I think that's a great approach. And if the candidate doesn't like what the employer is saying in response to those sorts of inquiries, it's probably a really good indication of what the employment relationship will be like. Employers should be willing to provide the information being asked for and to try to make the employee feel very comfortable with the situation they're coming into and with what the employment is going to look like. And if they're not prepared to do that, that's, again, probably another red flag.
A red flag. I mean, even, amidst the excitement and sort of the desire, to join this organization, because we all have sort of an idealistic expectation of what the employment relationship is going to be like. And I think that the more we can test those red flags, the more both parties are going to be happy with in the long term. So Amy, as you know, at the time of this recording, for the benefit of the listener here, we're experiencing the challenges of the COVID-19 pandemic. What are you seeing in employment law trends today relative to the pandemic?
Well, the COVID-19 pandemic has it's raised a lot of new and unique issues in employment law. I've spent a fair bit of time in the last few months thinking about different solutions for problems and thinking about things in a completely different way, because there are so many additional considerations that you have to add into your normal approach to things. And when this all began, obviously employers were laying off employees, businesses were shutting down. I was dealing a lot with those sort of issues and what that looked like. Other employers were scrambling to set up employees to work from home and making sure they had all the equipment they needed to do that. Or they were trying to ensure the proper social distancing in their workplaces if they were going to stay open. And so I had a lot of phone calls about having employees work from home and how you can ensure those employees are being productive and making sure the work is getting done, as well as a lot of phone calls about constantly changing requirements that were coming out in terms of social distancing and cleaning and things for employers who are staying in their workplace. But after that sort of initial wave of problems and everybody kind of settled into what they were doing, there was some support come forward from the government for payroll, and some of the employees were looking to recall their employees back to work, and a lot of them have had issues with getting those employees to come back. And for employees that are at the lower end of a pay scale, a lot of them are happier and in some cases feel safer staying home and getting the CERB benefit that the government has provided for. So, an employer recalls the employee back to work, the employee refuses to come, and the employer has left in a situation where they have to terminate those employees. Now, I think this is pretty short-sighted on the part of the employee. Those CERB benefits will not go on forever. And I think employees may be a little naive to think that work will be there when their CERB benefits run out. But I think the larger issue, as we move forward and everybody's realizing that this is something that we are going to have to continue to live and work with for a long time, how are we going to reopen our businesses and work with social distancing and all the other requirements of increased cleaning? A lot of workplaces are not set up to have employees 6 feet apart all day long, and employers have to look at their workplaces and try to figure out how they can maintain that social distancing. Some employers are looking at having staggered work hours so that all the employees are not in the workplace at the same time. But I think the one really big thing that has come out of this is that employers have learned that the technology is there and available to have employees work from home, and that employees can be trusted to do that work from home and be productive. So I expect that a number of employers will actually move to having some work done at home on a permanent basis, either having employees report to work on a rotating basis, maybe be in 1 week and out 1 week, or they may just be home permanently. The other thing that I think we will see is that some employers may decide that they're going to reduce the size of their workplaces and reduce the amount of office space they have as they move more employees to home. Now, working from home has its own issues. We could probably do another one of these calls just talking about all the things that could come up in that. But I think we've seen in the last few weeks that there are a lot of options available for people to carry on business without meeting face-to-face. And I think as people become more comfortable working that way, there will be fewer and fewer workplaces that are operating Monday to Friday, 9 to 5, with their full workforce in them. So I think, these changes may have been sort of slowly coming anyway, but I think that, this pandemic has has forced us to make the changes, and now we realize that we can operate and change our businesses and work in a different way. So I think that this pandemic will have a long-lasting effect that goes beyond the pandemic itself, and when there is a vaccine found, I think some of these changes will still continue to exist.
I agree. It certainly has been a renaissance in terms of the employment trends in the labor market. There's no question. Organizations who had strict policies around working from home, not working from home, and meeting clients face to face have been forced to do that. So it's been a transformation for absolute sure. And so Amy, it's been an absolute pleasure to have you here today. I've enjoyed the conversation. And what's the best way for individuals to get in touch with you if they would like to contact you directly?
Probably the best place for people to contact me would be at my email, which is abradbury, BRADBURY, @wickwirehome.com. Or they can call my direct line at work, which is 902-482-7010. They can also visit our website, which is wickwirehome.com, to see my profile and the other lawyers in the office who work in our labor and employment group.
It's fantastic. Excuse me. Thank you so much. And if the listener wants to get in touch with Maureen at Westgate, I can be reached at Maureen@westgatecareercoaching.com, and our website is westgatecareercoaching.com. So that's all for today, Amy. Again, it's been a pleasure, and I hope to get to do this again sometime.
Thank you, Maureen. It's been a real pleasure speaking with you as well.
Thank you. Take care.
Thank you for tuning in, everybody. Just a little disclaimer that we wanted to share. This recording is intended to keep our clients and friends informed of developments in the law and emerging issues. It is intended for general information purposes only. In preparing and circulating this recording, Amy Bradbury is not providing legal or other professional advice. We invite you to reach out to Amy or Maureen if you have questions about any issues raised in this recording. You can contact Amy at wh@wickwirehome.com or call her at area code 902-429-4111. You can contact Maureen at westgatecareercoaching.com. Thanks again for listening, everybody.
Thanks for listening to Get Hired Up with Maureen Farmer. If you enjoyed the show today, please tell a friend and write a review for us. For customized resources to help you get hired up to your next C-level position, visit westgatecareercoaching.com.